Welcome to episode 222, 222 of AAA Weekly Knowledge Series. And as usual, we are again coming with a latest subject. That is the discussion paper issued by IBBI on 30th of June 2026, named as Discussion Paper on Strengthening Resolution Outcome in Real Estate Insolvency. Primarily, this obligation came on IBBI via the Mansi Brar judgment of Honorable Supreme Court. It was the judgment Mansi Brar Fernandez versus Shubha Sharma, and this judgment was dated 12th September 2025. And in this judgment, primarily the Honorable Supreme Court held that the speculative buyers cannot be classified as the allottee as per section 5, subsection 8, clause F. So it was a differentiation between a genuine allottee who actually has invested his money for living and those speculative investors who are actually investing in a real estate project for profit. And this judgment, in fact, at the last part of the judgment, in fact, the court also directed IBBI that IBBI will make regulations for real estate in consultation with RERA to frame sector-specific guidelines, including timelines for project-wise CIRP and safeguards for allottee, and specifically to devise a mechanism enabling handover of possession to willing allottees where substantial units in a project are complete. In fact, there is a basic shift from value enhancement for the committee of creditors to a kind of a consumer comfort case. So in these regulations, we have seen that the principle is shifting from maximizing the valuation or preserving the valuation, but it is shifting to the consumer complaints or kind of recognizing the pain of home buyers, also recognizing the compliances of RERA in this discussion paper. So, Ankit, this discussion paper, in fact, we would be attending first all the 13 proposals in this discussion paper, which are inserted in CIRP regulations at different regulation numbers, and the impact is strengthening the CIRP of real estate companies. But more or less, you would see the obligations of a resolution professional has increased multifold in case this entire discussion paper becomes regulations. Multifold additional responsibilities on the resolution professional. So we'll deal with each and every proposal. But first of all, the background that we have to give. The background is that in fact, there are this is called the third wave of the real estate sector specific regulations. The first wave was in November 2023, when the discussion paper was released, and then in February 2025 the amendment was also made when this RERA regulation 4D, in fact 4E was inserted, and regulation 18.4 was inserted. And then again a second wave came when the IBC Amendment Act 2026 was being discussed. But finally, this is the third wave, and this is the present discussion paper. Also, in this discussion paper, there are no concrete proposals. Although we will also discuss what has not been attended to, which is again a problem statement as of now, but has not been attended by the discussion paper. Maybe because of the statute or basically the powers of the IBBI, that may be the reason, because nothing can actually go beyond the code. So therefore, the IBBI has remained within the powers given by the code, and there are many other issues which are still left outside this discussion paper, probably because of that statute powers with the IBBI. So I think you can start with the proposals.
Yes, let's start. So proposal number 1 is an idea that multiple projects are sometimes, or rather frequently, part of one corporate debtor, and some of these projects, we see that we would recently understand in case of Supertech, in case of Vatika, there have been multiple rounds of adjudication in the before the NCLT, and NCLT has then said that okay, one project is under CRP, whereas other projects, or few projects are not under CRP, other projects are in CRP. So what has happened or what has been proposed in the first proposal is that in the first COC that the resolution professional does, he will talk about the various projects which the corporate debtor holds, and then he will take the opinion of the committee of creditors. If the committee of creditors say with the voting of 66% that these projects should be kept outside the CRP process and the creditors would not want those projects to be part of the CRP process, then the COC will of course give that mandate to the RP, and the adjudicating authority will finally decide if those projects can be kept outside the CRP. And of course, the reasons for doing that are also something that will be presented before the adjudicating authority. So the idea here is that project-wise insolvency for real estate is something that is being recognized, number one. Number two, there is an option now with the creditors that if 66% say that no, we want this project to be out, then there is an option available with those creditors. So the RP will not deal with a committee of creditors which part of which wants insolvency and part of which does not want insolvency. So
if this
how-
proposal, see, basically it's a complete reverse of what is presently going on through the judicial pronouncements. The present judicial pronouncements are saying that the once this order is passed initiating CIRP, thereafter the corporate debtor, the suspended management will come to the and CLAT, they will file an appeal that these are the projects which are already implemented or these are the projects which are not in default. So therefore, the only insolvency should be restricted to the project which is in default. So this is the present process. Now, in case this becomes law, in case the regulations are notified, then the entire corporate company would be admitted to CIRP. Then within the first month, before the first COC meeting, RP will collect all the information about all the projects, locations, status of construction, status of compliances, status of default, and will also find out those projects where there is no default or those projects which has already been implemented and still part of this company because there are some unsold inventory still lying in the possession of the company, in the ownership of the company. So after doing all this, then the committee of creditors will decide with 66% voting what all projects or what all businesses or completed projects are to be excluded from this process. That application will go to adjudicating authority, NCLT, and NCLT finally will decide what all projects would be excluded. I think some clarity will be required that if some projects are excluded, then whether the suspended management power would be revived for managing those projects, whether section 14 would be applicable to those projects or not. So that clarification is not there in the discussion paper. I believe the objective of the discussion paper is to seek guidance, to seek suggestions. So this can be one of the suggestions that the clarity would be required. What would happen to the moratorium and what would happen to the suspended management's powers would be kind of reinstated for those excluded powers or not. What I understand is when the application is going to adjudicating authority, these would be part of the prayers. Based on the prayers, the adjudicating authority will decide whether the moratorium would be applicable or whether the powers of the suspended management will be reinstated or not. So this is what is my understanding.
One more thing. So also the dynamics in the COC will also play out here. So now in case home buyers are for one group of asset, home buyers vote yes, then maybe 66% will be in, and if home buyers say no, then 66%. Now what then matters is that how will the ratio or what will be the percentage of home buyers from the solvent project and the insolvent project will basically decide whether 66% voting happens or not. So it becomes very difficult for a voting scenario to always decide if a project is solvent and it should be kept out. Also, there is a high chance that that project, which is financially feasible, is having some surplus which can always be used in the deficient project.
So while we are discussing with the judicial pronouncements, we also can see the legacy. So in real estate, I think the very first judgment which is important is the Pioneer Urban Land and Infrastructure Limited versus Union of India. This judgment came in 2019, and this in fact upheld that the home buyers are unsecured financial creditors under Section 5, subsection 8, clause F. So this was the first judgment where the allottees were identified and differentiated from the investors. Now the second judgment was Manish Kumar versus Union of India. This is basically upholding the amendment in the IBC where the application under Section 7 would be from 10% or 100 allottees of one project. So this was the first case where the project was given a status separately for the purpose of Section 7. Then coming to the Flat Buyers Association Winter Hills 77 Gurgaon versus Umang Realtech Private Limited. So this was the first case where the reverse CIRP was in fact ordered by the NCLT. So this is not discussed. So what I understand is the reverse CIRP is not finding any place in the IBC Amendment Act or in the regulations which are already notified and in this discussion paper. So the reverse CIRP is something which is it was an experiment which is not considered to be a successful, so that can actually be considered as non-existent now. Then the judgment of India Bulls Asset Reconstruction Company versus Ram Kishore Arora. This judgment was dated 11th of May 2023 from Honorable Supreme Court. This was in the case of Supertech, and this was a case when the project, the CIRP was restricted to those projects only where there is a default. So this is the first project in 2023 when the project-wise insolvency came into light through the judicial pronouncements. And then the next important judgment was Alok Sharma and others versus IP Construction Private Limited, where the RP was directed to execute sale deeds in favor of allottees who have paid in full on collection of remaining dues and costs. The doctrine, in fact, this was the seed for Regulation 4E. And also now another proposal, which is a proposal number 3, we'll come back to that. And finally, Mansi Brar Fernandez versus Shubha Sharma. So when we see all these 6 judgments, these are the legacy, and all the judgments are in fact finally, some got codified in the Act, some got codified in the regulations, and some are now finding the place in this discussion paper. But in this discussion paper, in case of project insolvency, the regulations are giving more and more information to the prospective resolution applicants, more information in IM, some mandatory information, but mandatory contents of the resolution plan also. So the project-wise insolvency is getting elaborated, and the transparency and also a little bit of shift from the committee of creditors concept to a consumer considerations, because the home buyers are also a consumer. So that is the total, that is a little shift. So Ankit, I think we can move on to proposal number 2 now.
Yes, let's move to the second one. The second proposal is about project-wise ring fencing. So how this discussion, this proposal has been talked about in the discussion paper is that under RERA also, every project is required to have a separate escrow account, it is required to have a separate account, funds are required to be kept separately. So the IBBI here in this part has said that yes, although some instruction was already there for this compliance to be continued for real estate projects, but they have now specifically proposed to add regulation 4DA, which says that the insolvency professional will be required to keep separate accounts with respect to all the different RERA registered projects, and will be required to keep separate fund flow for all the different projects. and that is where this ring fencing of funds in line with the RERA thought that if the money that comes from the allottees or other stakeholders into a project is kept or it goes through the funnel which is designed in RERA, then the chances of a default are minimal. So that is what is proposed here in this regulation. If I want to talk about this regulation exactly as to what is being talked about, so it says 4DA, the draft amendment says project-wise books of accounts and fund utilization. Then it says that where the CD has one or more real estate projects, they have to maintain separate books of accounts of such real estate project, and then all receipt and payment with respect to a project should be done through the separate bank account. Then it says that that wherever the requirement is there, the project wise statement of receipt and payment is also required to be presented before the COC. And then it talks about how the RP shall ensure that in respect of every real estate project, the fund utilization requirements provided under RERA are complied with during the CRP process. So in RERA, there is a requirement with respect to fund utilization which attaches to CA certificates, chartered engineer certificates with respect to level of completion. So that is what has been now mandated in this regulation.
So Ankit, since this discussion paper, the draft regulations are made in consultation with RERA, and RERA has actually now been brought in to the regulations. One, that it is also in subsequent proposals, we are at proposal 2, in subsequent proposals, even the RERA also would be actively involved in the resolution process, in implementation process, and also RERA would be involved in providing information to RP. That is what we are coming. But for the time being, we are not sure whether this the IBC regulation would be applicable to all real estate companies. But technically, we understand that all the real estate companies are maintaining separate books of accounts already. As far as this project books of accounts are concerned, that actually can be understandable. But when it comes to the common books of account of the company, and that common books of account would be very clear that it will have some common expenditure, some common loans, and some common collateralization, cross collateralization. All this, whenever the difficulties will come, the RP will manage with the help of the committee of creditors. But one thing is very clear, that if the fund utilization is supposed to be managed, then 70-30, like the 70% of the total funds collected from the allottees would be utilized for the construction, and RP will actually have to struggle how the CIRP cost and the other common expenditure will be dealt with. Because normally the real estate companies are coming to the RP completely having empty bank accounts. So in case there are some allotment money which is coming, and 70% can be utilized for the construction, and the how the CIRP cost, common expenditure, the process cost would be met, that challenge of course would be decided by the committee of creditors. That's what I believe. So therefore, this is another proposal which will add a lot of responsibility on the RP to comply with the RERA regulations also, in case the company is being kept as a going concern.
So coming to proposal 3, we already had a regulation in CRP called 4E. Now, 4E talked about how during CRP the possession of real estate projects can be given to the allottees on approval of the COC. So COC had to approve, and then the possession could be handed over. So what is the proposed amendment here is that two alternatives have been talked about. One, it says that with respect to completed units, where as on insolvency commencement date, certain units were completed. Now there's a proviso which is added that for the purpose of giving possession for those completed units, no COC approval is required, because many home buyers or much litigation was around this idea that because COC is not allowing this possession to be given to completed unit holders, then that used to block a lot of things. So if the unit was completed as on the CRP commencement date, then without COC approval, the possession can be given. The second change that is being brought in is that a clarification has been brought in that the RP will not need a unit-wise permission from COC to hand over the possession. The RP can have a in principle approval from the COC, which designs a fit case for possession to be granted, and then the same can be done with a blanket COC approval, which is an in principle approval. These are the two changes that will help the resolution of real estate projects, avoid litigation from those home buyers who simply want their flats and they are constructed but they're not able to get them because of hurdle at the COC.
So I think, Ankit, this option 1 and the option 2 in the proposed regulation, I think automatically even the hybrid also would be possible, because there will be some units which are already complete as on the insolvency commencement date, and there are some units which actually would be complete in case the company is being kept as a going concern. So the regulation would be applicable to the first scenario as well as the second scenario. So there is nothing like option 1 or 2. These are both the options are possible. That's what I'm saying. However, in the first thing, the RP is not required to have a committee of creditors vote. However, in the second, there is a requirement of committee of creditors vote, because in case the RP is constructing and completing the units, then the RP will take the permission from the COC that now whether he can hand over. But the definition of complete is not really provided in the regulations, because see, the completion can be different from state to state and from classification of the properties, maybe residential, commercial, any other. So the complete means whether it should be a completion certificate based or occupancy certificate based, or it's a physical completion based, or as per the RERA definition. So that completion, like what exactly will mean completed, that is not defined in these regulations. The only suggestion that we can give is that it should be defined so that the RPs are not facing any difficulty or litigation. Now, the other question is, like, when we say the registration, what exactly the meaning of registration would be, because it will require stamp duty, it will require mutation, and also the NOC from the lenders. Is there any direction to the lender that they will provide NOC? Because some lenders, they have already created a charge, because the registrar of assurances, the registrar of documents, they normally have some kind of overriding directions that they would not register any document of this particular project till the time their lien is marked, is cleared. And that is also a difficulty, because see, in Uttar Pradesh, if the Noida Authority dues are not paid, Greater Noida Authority dues are not paid, then the registrar will not register that property. So how would this registration also would be possible without even getting the no dues from the lenders and from the land owning agency?
So registration is not being talked about in this. It is only limited to possession.
It is only handing over.
So it is only possession, number one. Registration is not being talked about in this regulation. The second part that you said, that how will an encumbrance that is there. So let's say there is so encumbrances for registration. Number one, there can be some dues because of which registration is not happening. And secondly, with respect to unsold and sold, wherever there is an agreement to sell with respect with an allotee, normally you don't have other encumbrances disturbing that sale process. But yes, where a financial creditor has an encumbrance on an unsold inventory, that of course should not
be. The encumbrances
sold.
are normal for unsold inventory, for receivables. So if an allotee has booked a property for 50 lakhs and he is paid 30, so the balance 20 is encumbered to the working capital lenders.
So in case that 20 comes in, and let's say that 20 is then used as part of the project construction, you're saying that that 20 encumbrance is in some way limiting the options of the financial creditor.
My understanding is that no dues from the financial creditor. That is probably the reason that the COC approval was required. But now saying that the as on the date of ICD, if there are completed units, no COC approval would be required. That actually means that it is basically shifting the focus from preserving the value of the corporate debtor, rather than it is shifting to consumer protection. So otherwise, there are liens, there are charges, there are the financial creditors claim on those inventory.
Let's move to proposal 4, and I think we will have to rush it up a bit. So, proposal 4 is a simplified claim form. So, CA form, the existing one, was understood to be not specific to allottees of a real estate project. It was, of course, for creditors in a class. So, now we have a new form which is called CAR. CAR is supposed to have part 1 as particulars of the allottee, that is name, PAN, ID proof, mobile, email. Part 2 will include project and unit details, that is RERA number, TAR, date of allotment. Part 3 will talk about financial details, what was the total purchase value, amount paid, etc. Part 4 will talk about preference of relief, that is whether the allottee is interested in possession, allottee is registered, allottee wants registration, allottee wants refund, what does he want. Then possession status as part 5, and part 6 is supporting documents, that is agreement for sale, allotment letter, payment proof, etc. So this is how this draft form has been made. The draft form is part of the proposed the discussion paper, and that draft form is of course talking about all these details which are specific and which will be giving a lot of information for the RP to collate. So it will allow standardization of the information that is coming from the claimants.
Yes, Ankit, but then the proposal 5 that we are talking now is a kind of, it's a consequential to the proposal 4, because in case this form, the R, like which is the form CAR, if whatever information is being collected from the home buyers, all that information is supposed to be collated by the IRP and RP, and it actually will disclose this information in the IM. Now, this information which is being collected in form CAR, like the what is the preference of the allottee, whether he would need possession, refund, or he would need only conveyance or registration or transfer of title or any other leave.
Yeah.
So this is what actually, as per this regulation 36 sub regulation 2, there is a new clause which is being added, that is JB. In that clause, this would be the information which is required to be mentioned in the information memorandum. Now, the only difficulty that I'm trying to face is, like, the many times the allottees are also not very clear whether they need a refund or they need a possession. So in case they see that the RP is able to continue the construction and there are some good feeling which has started coming, then they even shift the refund to the possession. In case there is an appreciation in the real estate market, then they also can change their mind. So this is also like kind of changing. So till the IM, I think the allottees or the claimants, they will keep changing their preferences, and that also may add to the additional work or additional complications to the RPs. And also maybe the resolution plan also would be accordingly designed in case the IM provides all this information.
So, if this information is not captured anywhere, that what is the requirement? So, see, currently the claim form come, like let's say 500 claim forms come to a RP, and then he is doing separate procedures or conducting separate procedures to understand what do they want. So, of course, there will be few people who are wanting just the registration because they already have possession. There will be few people who are wanting only refund. So that was not clear in the form. So now that information will flow in naturally. I believe that this was anyways part of the process, but it was done separately beyond the claim forms.
No, this is also welcome that the preference of the allottee, preference of the claimant should be recorded. But then when the claim form is presently being filled, the CA, now it will be CAR, I have seen the allottees, they fill this information, like they fill the information about the payment made, total payment made, then they might even claim 8% as the interest rate for the purpose of voting share. Then they might even claim any of the RERA order or the consumer court order where they have actually been awarded some kind of interest. And they might even add some kind of penal clauses in the builder-buyer agreement as their claim. So all this, the RP, IRP has to be very careful in verification of these claims. Earlier, before the amendment, 2026, it was collation of the claim, but now it is a verification of the claim, and for each claimant there has to be communication. The RP is supposed to send a communication and giving reasons why it was accepted, why it was rejected. So that actually will increase the work and also may increase the litigation. But yes, this is required, and once the real estate cases will become difficult, I feel the compensation will also accordingly increase. That's what is expected of it.
So coming to the next one, that is Proposal 6, which talks about mandatory disclosures in IM for real estate CARP. Here again it says that there was no separate regulation which required an IM to disclose real estate specific information that is much required for any resolution applicant to take a decision. So now it specifically says that in case of a corporate debtor having a real estate project-wise details including total number of units sanctioned in the project with segregation of completed units and units under construction, total number of units in the project with details of sold and unsold units, stage of completion of the project, stage of completion of common areas, common facilities and other amenities, and details of statutory approvals, permissions and registrations applicable to the project. So this is of course something again which is standardized the IM. I don't believe that this information would not be part of any well-made information memorandum for a real estate project even earlier. But I think it standardizes the IM to make sure that this will be part of the project.
I would say, again, I'm saying that it will just definitely add. The only situation that I'm afraid is if the promoter is filing appeals against the ICD, against the insolvency commencement order, then he would not provide this information and he would actually delay the process. But of course, the RP actually can justify that the information was not available. So whenever information will come, he will only provide to that extent, because the IM is also a kind of dynamic document. So therefore, IM can change whenever the information is available. But very important change which is proposed in this discussion paper is appointment of an independent technical professional to assess cost to complete the project. So this is where it is proposed in Regulation 4F, by inserting a Regulation 4F. Now, of course, with the COC approval, although the regulation is not says that, but then any such professional would be appointed with the permission of the Committee of Creditors. It may be a project management consultant, it may be a chartered engineer, it may be a person who has a lot of experience, or any entity having experience over the projects. That particular independent consultant will make an estimates of the total cost of construction and the total time which will be requiring to complete this construction.
It's much more. So it says the assessment should include physical status of construction and percentage completion. So actual physical status and percentage completion, project approvals, registrations and statutory and regulatory compliances, inventory position including sold and unsold units, estimated cost required for completion of project and its phases, milestone-wise funding requirements, realistic timelines for completion and delivery, and such other information as may be necessary. So this is what has been listed, a total of 8 points here, which of course includes others, but yeah, this is specific that all this information should be validated by this independent consultant. I think many real estate projects that we have managed, I think, has there been any project where we have not appointed this kind of a consultant?
Yes, we have not been able to appoint such kind of consultants, only because of the one, that there is no clarity what kind of consultant will do this job. Not much professionals are identified, and the COC would not approve such heavy cost for completion, construction completion. Yes, in some of the cases we have appointed, but more or less it is left to the resolution applicant to make an estimate of the construction cost. But see, like some of the suggestions that we can give, one, that the what kind of consultants can be appointed, that can be clarified in the regulations. Two, whether this consultant will also be considered as professionals appointed during CIRP, and the fee which is being paid to this professional will also become like eligible for the IBBI fee which is charged on all professional fees. That actually can be clarified. But yes, with this information in hand, the intent of the IBBI is that there should be a complete clarity about a project. Unsold inventory, the claim classification of the home buyers, their intent, whether they want possession or they want refund, the uh, stage of construction, the pending construction cost. So the entire project economics would be ready with the resolution professional. So he would be able to market it in a better manner, and he will have more participation in the resolution process. He would have more resolution applicants, and this will maximize the offers in the resolution plan. So with this, the process may be slightly delayed because getting everything done within this period, that may be difficult, but this is what is in fact most welcome, that in case this is also mandated, then the project economics would be available for the RP, and RP would be able to even arrive at the liquidation value of the project very clearly.
So one regulation 36 before invitation of EOI under regulation 36 said this is compulsory now. So the timelines are important, that this appointment should be done sooner in the process, otherwise the resolution plan invitation process cannot start.
Yeah.
And that's, I think, an important part. So this becomes very, very important. Even if an independent professional is not able to come with absolute clarity based on deficit information, maybe non-cooperation from the promoters, having an estimate on the table on best effort basis would still be required.
So the another proposal number 8 is the like substitution of regulation 38A. These are the mandatory contents of a resolution plan. Now, in the mandatory contents of the resolution plan, it is proposed that every resolution plan for a real estate project must additionally provide project-wise a unit census with sold, unsold segregation. Next, treatment of allottees.
It's more than that. It's total number of units sanctioned, constructed and under construction with segregation of sold and unsold units.
Yes.
Then it says treatment of allottees including possession of units, execution of conveyance deed, registration or transfer of title in respect of unit already handed over or otherwise eligible for conveyance, refund of amount paid or any other relief. So very, very detailed reliefs will have to be provided for all the projects. Where the information memorandum includes details of allottees who have not submitted their claims, the resolution plan shall provide for treatment of such allottees. Then timelines for completion and delivery of possession specified project-wise, phase-wise or tower-wise as applicable. Then consequences and actions in case of default by allottees, including failure to pay revised or balance consideration, and periodic reporting including submission of progress reports to the monitoring committee. So these are the parts that are part of
this
this
is also
proposal.
in fact welcome, because see, based on our experience, all these clauses, in fact, we have already made it as a mandatory in all our resolution plans. Otherwise, our resolution plan will be subject to litigation. So we have, in fact, all our 30 cases that we have handled so far, we have added all these clauses in our resolution plan. So that is something which is very well being done, but now it has actually been brought to the regulations. Now everyone will do, and therefore it will actually be improve the implementation of the resolution plan without litigation.
Next is proposal 6, where it talks about enhancing the composition of monitoring committee in real estate cases. So the proposed amendment is that in regulation 38(4)(b), which governs the constitution of the implementation and monitoring committee, now it says that the monitoring committee will include authorized representatives of allottees or any other representative of the allottees chosen by majority vote, and a representative of the concerned real estate regulatory authority or the concerned land development authority as may be applicable, subject to their agreement to participate. So in case RERA or maybe Noida, in case of a land development agency, wants to be part of the IMC, then that has been provided for. If they say no, we don't want to be part of the IMC, then of course one can't force them to be here. But yes, this option is granted, or this requirement is granted, that if RERA or land authority, land development authority says we want to be part of the committee, then it has to happen.
Yeah, I think this is it's like the IBBI is trying to coordinate between the agencies and between the regulatory authorities. So the only difficulty is that in case we make them part of the implementation committee, and in the meantime they are litigating for the amount that uh, they have been offered in the resolution plan, then it becomes counterproductive, because till the time the litigation is pending before maybe NCL 80, they would not cooperate and they would try to create hurdles in the implementation committee. So that is the only difficulty. Otherwise, but then it is also very important that it is with their consent. In case they are ready, only then they can be made a part of the IMC, Implementation and Monitoring Committee. So this is okay.
Proposal number 10 talks about enhancing transparency in functioning of authorized representatives. So, two problems that have been identified in this part by IBBI. One is that authorized representatives hold consultation meetings with stakeholders, but those consultations are not recorded anywhere, they are not kept a record of, and therefore there is never an evidence, or rather a means to confirm whether those issues have been addressed or talked about in the COC meeting. And then it says that the creditors in a class are required to exercise choice of authorized representative at the time of filing the claim, when they don't know anything about the AR, they don't know their profile, and etc. etc. So the proposed solution now is one, to when the offer is given with respect to the authorized representatives, it will be along with a hyperlink of the brief profile of the IP who is being proposed as an authorized representative, so that the home buyers or the allottees can choose. The second part is that procedural transparency has been for that 16B, a new regulation is proposed, which says that wherever the authorized representative of a creditor has meetings with stakeholders, he will submit the minutes to the RP, and then he will, and also the COC minutes, that is regulation 24 sub regulation 6, it says that a new sub regulation 6A is added to say that the COC minutes must record how the issues which were communicated to the authorized representative have been addressed in the committee of creditors meeting. Good amendments. I think it will allow a lot of transparency, although I think now the COC meeting will be longer, because the issues might take a lot of time to be addressed.
I believe the instead of having observers from home buyer groups to the COC meeting, it is better that the home buyers actually should interact with the AR, and there should be minutes of those meetings and also the kind of number of parties attended. So then those subjects can be discussed in the COC meeting and it can be part of the resolution minutes. So I think this is again welcome, and so we are continuing with the next proposal, that is the additional safeguard prior to liquidation, that is being proposed as the regulation 39D. Now the intent here is that in case there is any inevitable possibilities of liquidating the company, then the proposal is that the before placing a liquidation proposal before the COC in a real estate CIRP, RP must place a detailed note setting out efforts undertaken to identify completion-oriented solution. Prospective resolution applicants, developers, investors, funding arrangement, allottee-led proposals, whether proposals were received, and reasons why alternatives are not feasible. COC minutes must record consideration of alternatives and the reasons for conducting liquidation is the most feasible course. The Section 33 application to adjudicating authority must annex a note and the relevant extract of the COC deliberations, all through proposed regulation 39 capital D. So this is a kind of safeguards that before a company is pushed to liquidation, the committee of creditors, RP, and the other stakeholders must consider these things and then only the justification would be placed on record for liquidating the company. And like, see, the next proposal is the resolution professional and RERA coordination. Now, the in this proposal, it is the it will come probably through the circular. There are three stages of this proposal. One, the RP may seek from the concerned RERA project registration details. These are the details which can be sought from RERA in case it is not available through the promoters. Project registration details, sanctioned plans, registration status and extensions, allottee records, escrow account status, approvals and compliances, and may rely on RERA records where the CD's records are not available or are incomplete, subject to verification and reconciliation. Of course, verification and reconciliation is the duty of the RP. Then the RP shall ensure compliance with RERA and its rules and regulations during CIRP. Now, the RERA is now imported in the CIRP process. That in case the company is supposed to be kept as a going concern, then the RP is also under obligation to comply with all the rules of RERA. And the third is beyond regulations, like beyond regulations 18 sub-regulation 4 participation, the RP may invite the RERA to give written views on the regulatory feasibility and implementation aspects of plans under COC consideration, which the RP shall place before the COC and PRA. So this is also which is the to give written views on regulatory feasibility. So in case the RERA says that no, it is not possible to complete this project because of various non-compliances which may be technical, then of course that must be placed on record. So any of your view on this?
I think it's good to promote, interaction with RERA, and this is something which will allow two regulations which are safeguarding RERA as a regulation to continue working even in IBC. So this whole dispute that we have seen, RERA versus IBC, I think will become thing of the past.
No, I think this is good. But see, but then handling real estate cases and also handling RERA, maybe it would be a requirement that in case the corporate debtor is not having any RERA consultant, then the COC may have to approve a RERA consultant so that the advice of the RERA consultant would be implemented. So the last proposal is the site level disclosure of the CIRP, because see, this is coming as proposed regulation 6 sub regulation 2 and clause BC, which says that the RP will put conspicuous signboards at each project site and notice boards at the registered office, corporate office, site office, sales office, and any other stakeholders accessible office, stating that the corporate debtor is under CIRP and giving the RP IRP's name and contact details through insertion of this clause BC in the regulation 6 sub-regulation 2. So these are various proposals, and I believe this is also very good proposal. So I think we have discussed what all is there in the proposed regulation. We have seen what is there in the discussion paper, but I think we should also say that the real estate project is not defined, but we can say that yes, the RERA definition would be applicable. That's what we can find out from the other part of the IBC and the regulations. And also the reverse CIRP remains uncodified, that we've already said that the reverse CIRP is not something which is being promoted. The dues of land authorities, land development authorities, that is something which is not at all considered. The claims of landowner private parties and also who have entered into a general development agreement, joint development agreement with the corporate debtor, their entitlement of the constructed space is also not covered in these regulations. And of course, with all these additional compliances, the timeline for the CIRP cases may even increase a little. And this is also something which is already there in regulation 46A, that the exclusion of the allottee possessed unit from the liquidation estate. but that actually will be continued. And whether the association of allottees can become a resolution applicant, yes, they can become. They are already becoming the resolution applicant. So this is what is probably all about these regulations. But Ankit, in case we can have about 5-6 minutes on the other discussion paper, I think you can take
Yes,
up
I
that.
will. I will go through those changes that are separately talked about. So it is titled that strengthening the regulatory framework and amendments to CRP liquidation and personal guarantee to CD regulation. So it's a mix of various feedback that might have come to IBBI. So the first one is COC approval for appointment of valuers, deadline for valuation reports, and confidentiality till plan receipt stage. So far the regulation was very clear that okay, values will be appointed by the RP, the fees will be approved by the creditors, and the valuation report will come to the RP, and the RP will release it to COC members only after getting their NDA confidentiality certification. So now what is the new section that is being talked about? So it says that each registered valuer appointed under the CRP process uh, shall submit its valuation report, including the fair value and the liquidation value, to the resolution professional in a sealed cover or through secured electronic mode with restricted access on or before the last date of receipt of resolution plan. So this is something that the date was still there, last date of resolution plans was already there, but yes, now there will be a password, there will be a sealed envelope, so the RP also doesn't know the valuation report. That is the intention now. Earlier the RP was having access to the valuation report, now he will not. The valuation, the RP shall provide information memorandum to each registered valuer appointed under sub-regulation 1. So there was no provision for the registered valuer to get access to the IM. Now there is a provision, and it says that the IM will be taken into consideration by the registered valuer when he is doing the valuation. Then the resolution professional shall maintain confidentiality of the fair value liquidation value, and he shall open the valuation report only before the committee on the last date of receipt of the resolution plans. So this is how this is being structured now.
So that means the resolution, valuation would be now received in a sealed envelope or in a password protected file. It will be opened only uh, on the last date for receipt of resolution plans. It will not be discussed with the committee of creditors before that. So what happens to those regulations where it is the valuers are required to discuss with the COC members?
So the methodology was anyways not discussed with the valuation report in hand. It was always discussed based on the understanding available with respect to various assets, that how will the assets be valued. But the only practical difficulty that can come across is that there's a lot of information that flows. So valuer asks for an information, RP gives that information. Then valuer asks for information, RP arranges that information from the CDN or the suspended management, then gives it to the valuer. So this to and fro happens a lot. And what happens is that at times we have observed that when we give a draft report as a valuer to the RP, then after understanding that yes, lack of information results in this kind of an approach for the valuation, some additional information also comes in, allowing the final report to be a better version of the valuation exercise.
So that means when these claims will be verified, the claims will be verified as a total claim of a particular financial creditor. Because see, the bifurcation of the total claim between the secured debt and the unsecured debt would be possible only after looking at the valuation report.
This IM will give. IM will have information with respect to what are the assets, who are they secured against, who are holding a security with respect to which assets of the CD.
But then the secured part quantum and the unsecured quantum will be based on the valuation report, and that would be disclosed only on the last day of receipt of resolution plans. So that means the classification of secured and unsecured actually will be delayed till that time. Otherwise, see, this is based on the valuation report.
Valuation of secured will be delayed till that time.
Yeah, valuation. See, the classification of a particular claim between secured and unsecured, that will be delayed.
So
That would be delayed.
There is no difficulty in that being delayed as part of the
Because the voting power remains the same. Voting power remains the same, so that will be delayed.
So the only difficulty and the only suggestion here that might help is that the draft valuation report, without certain elements which are disclosing the valuation, can still be allowed to be exchanged before the final report.
Yeah, but that is not possible because it is only like he has to be present. The valuer will be presented before the COC to discuss the
methodology.
That's one thing.
But the valuer needs to provide an interface to say that this is the information that I have received, this is the information I have not received, these are the assumptions that I am taking in absence of information that was not made available. This part, without the values being disclosed, should be part of a draft report interaction.
Anyway, I think this is still better because in case we disclose the valuation to a creditor, then it will be kind of a lot of struggle because everyone would try to increase the value of their asset because of their security interest. So this is in fact is a relief to the valuers because their report will be completely private and it will be confidential.
Also, the fair value disclosure in the IM has been now done away with because that would have required the valuation report to be available earlier. Then the second one is intimation of cessation of interim moratorium. So this was, I think, part of the feedback that we also discussed when the new regulations had come into picture, that the IRP who is appointed in a personal guarantor case can report or can inform the creditors that the moratorium now is no longer available to the personal guarantors and that they can continue with the SARFAESI proceedings or other proceedings while the application is still pending. So that is something that they have made proposed here. Then we have clarification with respect to RP's continuation in office pending disposal of Section 12A. There might have been some confusion that after filing the 12A application, the resolution professional has demitted office. So now it has been made very clear that till the time the adjudicating authority takes a decision on 12A, the RP is not discharged. He is supposed to continue his duties, and there should also be a mechanism for him to kind of talk about the the fee that he is taking for the effort or the time that he is spending, because he will have COC meetings, he will conduct the process as if the process is ongoing. Modification, the next one is modification of entries in the list of stakeholders. So this has again something which was removed. So stakeholder intimation under regulation 31 was proposed in liquidation regulations. So now it is being omitted because there is no requirement to intimate change of stakeholders to the NCLT now. So that is what has been omitted as a procedure. So these are the 4 changes that are proposed in the second discussion paper, which are based on the feedback that IBBI must have got.
So these are the 2 discussion papers that we have received. One on the real estate and the other is on the combination of CIRP, liquidation and personal guarantors. So out of these deliberations, we have also given some of the suggestions. Our viewers can capture these suggestions and can pass on to IBBI, as we will also do the same thing. Thank you very much.
Thank you.